Hello everyone, I'm Debojit Das and this is Courts Today by LiveLaw, your everyday stop for everything important across India's courts. With the Diwali lights out in the open, the courts still haven't stopped working. So, let's get into it. Starting off with a crucial ongoing matter before the Supreme Court challenging the Election Commission of India's special intensive revision of Bihar electoral rolls. The court has opted to adjourn the matter until November 4th. The core contention was articulated by Advocate Prashant Bhushan for the ADR, who fervently urged the bench to direct the ECI to immediately publish the complete final list of voters, specifying all names added, deleted, along with the reasons for those changes. Bhushan stressed the urgency, noting the last dates for filing nominations for the two phases of the upcoming Bihar Assembly elections are imminent. That is October 17th and October 20th. Senior Advocate Rakesh Dwivedi for the ECI countered this demand, confirming that the ECI is already in the process of publishing the final list and questioned the need for a specific judicial directive. The ECI's affidavit further strongly denied the petitioner's claim of disproportionate exclusion of Muslims, labeling the argument a communal approach since the ECI's database does not record an elector's religion. Dwivedi also highlighted that despite the Supreme Court's earlier order ensuring free legal aid, the ECI has received no appeals against deletions. The bench comprising Justice Suryakant and Justice Joy Malia Bagchi expressed confidence in the poll body's integrity, stating, "We have no doubt that they will fulfill their responsibility. They are bound to publish." While allowing the ECI time to publish the list, the court also noted the ECI's affidavit refuting the allegations of largest ever shrinkage of electoral rolls and asked the petitioners to respond. The court adjourned the hearing, including the constitutional challenge to the ECI's power to conduct the SIR, until November 4th. Next, we take a look at the Supreme Court's approach, which was filled with significant hesitation to formally reopen the controversy surrounding Advocate Rakesh Kishore, who last week attempted to throw a shoe at Chief Justice of India B.R. Gavai, even as it deals with the fallout of the incident being glorified within certain aggressive, communalized social media spheres. Senior Advocate Vikas Singh and Solicitor General Tushar Mehta urged the bench to urgently list contempt proceedings, for which the Attorney General has already granted consent, arguing that social media was glorifying the act and causing some damage to the institution. This appeal comes against a backdrop where such extremist actions, often cloaked in majoritarian religious justifications, are increasingly weaponized to undermine constitutional institutions. However, the bench prioritized letting the matter have a natural death. Justice Suryakant noted that the Chief Justice of India himself was extremely magnanimous, while Justice Joy Malia Bagchi asked why the court should rake up an issue which, for our sake, is complete and finished. Bagchi critically warned that pursuing contempt now would only create episode number 2, stating that such incidents becoming money-spinning ventures on social media, advising to allow it to have a natural death. Despite the bar's insistence on the lawyer's lack of remorse, the court agreed to list the matter only after the Diwali vacations, opting to avoid further fueling the communal online machinery that feeds on such confrontations. Moving on to another noteworthy development coming in from the Supreme Court that dismissed a plea by the Telangana government challenging the High Court's interim order that stayed the implementation of a sweeping 42% reservation of the backward classes in upcoming local body elections. The controversy began after the governor allegedly kept the bill pending, prompting the state to invoke the principle of deemed assent, citing a recent Supreme Court judgment to enact the law. The respondents successfully challenged this reservation because when combined with existing quotas, it pushed the total reservation beyond the 50% ceiling, a limit established by Supreme Court precedents like K. Krishnamurthy and Vikas Kishan Rao Gawali for local body polls. Senior Advocate Abhishek Manu Singhvi, representing Telangana, argued vigorously that the 50% limit was not an inflexible rule and that the state had satisfied the mandatory triple tests by conducting a year-long, painstaking socio-economic household survey, claiming Telangana was the only state to have completed such an empirical exercise. However, the bench of Justice Vikram Nath and Justice Sandeep Mehta were ultimately unconvinced that the 50% cap should be breached. They dismissed the state's plea, directing the High Court to decide the main matter strictly on its merits. Next, in a culmination of several complaints across the country, two advocates have urgently moved the Supreme Court, challenging the Bar Council of India's decision to hike the non-refundable nomination fee for State Bar Council elections to an exorbitant 1,25,000 rupees. This steep fee, implemented via BCI circular dated September 25th, 2025, is being challenged as excessive and exorbitant, threatening the democratic spirit of the elections itself. The petition, filed under Article 32 of the Constitution, argues the fee is arbitrary, discriminatory, and abridges the fundamental rights enshrined in Articles 14, 19, and 21. Petitioners contend the measure makes participation a condition of financial muscle, effectively creating a divide between the haves and have-nots. While the BCI cited fund shortages after a previous enrollment fee reduction, the petitioners argue this is invalid, noting that bodies like the Bar Council of Delhi reportedly have large reserves. The advocates are urging the Supreme Court to quash the circular and ensure a free and fair electoral process. And to our final update from the Supreme Court today, as it reiterated a fundamental principle of due process, holding that it is improper and arbitrary to dismiss an employee based on a charge that was never mentioned in the original show cause notice. The case involved Jharkhand teachers appointed in 2015 whose services were abruptly terminated in 2016. The initial show cause notice alleged they were ineligible for failing to secure the minimum 45% marks for the intermediate trained teacher's post. The appellants successfully defended this charge by proving that as scheduled tribe candidates, they required only 40%, which they had secured. However, the employer, instead of accepting the defense, introduced a new unstated charge during the dismissal process. And the charge was that their marks fell below 40% if vocational subject marks were excluded from the calculation. Based on this new premise, for which the teachers were never given an opportunity to be heard, they were dismissed. Setting aside the division bench's decision, the bench of Justices Dipankar Datta and K.V. Vishwanathan held that this action was a fundamental breach of due process. Justice Datta observed that punishing a noticee for a different charge on which they were not put to notice offends due process and renders that order or action unsustainable. Consequently, the court set aside the termination, granting the teachers continuous service from their original appointment dates, including full arrears of pay. Shifting our focus towards the heart of central India, as the Madhya Pradesh High Court took suo motu cognizance of a horrifying viral video spotlighting the barbaric consequences of rigid, caste-driven social hierarchies still upheld in a lot of the parts of our country. The incident in Damoh district involved a young man from the OBC community who was allegedly forced in a village temple to wash the feet of another person and then compelled to consume the water as an act of his atonement. His supposed crime? Creating an AI meme of a higher caste man named Annu Pandey wearing a garland of footwear after the latter was fined by the Panchayat for drunken misbehavior. Justices Atul Sridharan and Pradeep Mittal expressed shock over the repeated instances of caste-related violence, citing a previous case where a higher caste person urinated on a tribal man. Justices Atul Sridharan and Pradeep Mittal expressed shock over the repeated instances of caste-related violence, citing a previous case where a higher caste person urinated on a tribal man. The bench lamented the rise of ultra-conscious caste identities, warning that if unchecked, this evil symphony of caste acrimony could tear apart society. The court immediately directed Damoh police to proceed against all visible perpetrators under the National Security Act or NSA, in addition to the existing FIR, to prevent the situation from escalating further. This decisive action slams the door on regressive social practices masquerading as justice. Next, in its neighboring state, the Chhattisgarh High Court today dismissed a plea demanding a special investigation team or an SIT probe into the alleged fake encounter of a purported Maoist during an anti-Naxal operation, holding that SIT intervention is warranted only in exceptional circumstances. So, what exactly happened here? The petitioner sought an SIT probe into the death of his father, a suspected Naxalite with 29 cases registered against him in Chhattisgarh, who had been estranged from his family since 2007. The petitioner and his mother assumed the deceased was arrested, tortured, citing 3 puncture wounds, and then executed in a cold-blooded manner. The state, however, asserted that the deceased died in a legitimate encounter, citing the recovery of arms and ammunition and the presence of nitrate in his palm. A division bench of Chief Justice Ramesh Sinha and Justice Bibhu Datta Guru held that allowing an SIT probe into routine anti-Naxal field operations would undermine the federal structure of policing powers. The court noted that the petitioner's claim of torture and fake encounter was based on a mere assumption, lacking material evidence. Furthermore, the court emphasized that injuries such as puncture wounds are not uncommon in the harsh terrain of forest operations and do not automatically imply extrajudicial killing, especially when the deceased's Maoist involvement was not rebutted. And finally, to wrap things up, the Andhra Pradesh High Court today voiced serious concern over the conversion of protected forest land for commercial use, ordering a high-level probe into the matter. The court was hearing a public interest litigation regarding the allotment of a 92.40-acre area in a village for mining operations to Sri Kumaraswamy Silica Mines. This land was originally earmarked as Forest Reserve Purambok, but was suspiciously reflected as Jungle Purambok before being allotted by the Revenue Department. A division bench of Chief Justice Dheeraj Singh Thakur and Justice Ravi Chimalapati questioned, "We fail to understand as to how an area which is otherwise declared as reserved forest could have been reflected as Jungle Purambok and allotted for mining operations." Taking a serious view, the bench ordered the formation of a committee chaired by the Chief Secretary and including the Principal Chief Conservator of Forests and the Principal Secretary of the Revenue Department. This committee is tasked with submitting a report specifically on whether the conversion was done to facilitate mining and what action should be taken against officials if the reclassification was done for mala-fide reasons. The court noted that mining operations are currently stayed by the National Green Tribunal and listed the matter for further hearing on November 19th. And that brings our Courts Today segment to a close. To access every order and judgment we mention here, visit www.livelawmedia.pvt and maybe check our pricing page too to take advantage of our Diwali sale. I'm Debujit Das. Thank you for watching.